Good morning and thank you. This is our last presentation of our conference. I'm honored to introduce Justice Richard T. Fields, an Associate Justice with the California Court of Appeals, 4th Appellate District in Division 2. Justice Fields graduated with honors from the California State University at Fullerton in January 1981, receiving his Bachelor of Arts with a major in sociology and a minor in Spanish. And he completed his bachelor's degree in only 3.5 years. He then received his Juris Doctor from Western State University College of Law in May of 1983, which he completed in just 2.5 years. He came to Riverside County, practiced at the Public Defender's Office, as well as did private practice. In 1991, he was selected as a court commissioner for the Riverside Superior Court, when he became the first African-American jurist in the history of Riverside County. In April 2000, Justice Fields became the first African-American judge in Riverside County when he was appointed. During the years of 2007-2008, Justice Fields was the presiding judge for the Riverside Superior Court. And in February of 2017, he was appointed to his current position as Associate Justice of the California Court of Appeals. With that, Justice Fields.
Thank you so much. So good to be here with you. I got to tell you, it's such an awesome experience. I never dreamed as a young person growing up in Santa Ana, and I remember I used to ride the bus from Delhi, which is a very poor area, to downtown to go to the library and just read. And I used to pretty much only read karate books, by the way. So don't think it was some big intellectual thing. But I never would have dreamed there'd be a time in my life I'd actually be presiding at the Court of Appeal, being a presiding judge of the Superior Court, having an opportunity to speak with distinguished lawyers like you guys. It's really quite an amazing experience. And I have to tell you, I almost was part of your association. I had a job in Los Angeles. I had a great job. When I finished school, I had a National Poverty Law Fellowship. I was working in LA. And when that was ending, I decided, well, you know, I'm going to get a job in LA. So I took a job in LA, and I liked the job. I was making really good money, and I was really enjoying it. But I did not want to move to LA because my boss said, hey, move to LA. So back then, they could buy a house in Corona in 1983 for $102,900. In LA, that was like $300,000. That was outrageous, right? It's like, oh no. And to me, it was like houses we grew up in, like really small, you know, not so nice. $300,000, all that money, you kidding me? No way, right? So I was driving back and forth, and the freeway was terrible. You think the 91's bad. Now it was really bad. Then it was like 2-3 lanes, right? It was horrible. So I said, I gotta get a job here where we live, because I live in Corona. And so I applied. Only county counsel was hiring, and the public defender was hiring. So I applied at both. And I got a call on the same day. County counsel called and said, you're one of our 3 finalists, congratulations. I said, awesome. A little later, about an hour later, the public defender called, you're hired, I'll take it. Some people say I made some political decision, right? But you're driving 2 hours a day, forget that. And like a year later, my wife got pregnant, right? Once I start getting home before 9 o'clock at night. So it's really quite an honor for me to be here with you. I have to tell you, once I finished school and start working, I decided I want to go back because we grew up in an area where nobody was sophisticated about anything. And so I first finished school and we bought this house. I thought it was the best thing in the world because we got this home, right? And it was $102,900, 10,000 square foot lot. Can you imagine that today, right? Man, if I kept that thing, my taxes would be so low. It's 1,300 square feet, and I used to think, I'm never going to move. I said, okay, I'm 24, I was out cutting the grass. I'm 24 years old now, got this house. It's going to take me 30 years to pay this off. I'll be 54. Ooh, I can't even think about that. Now I think, I wish I was 54 now. And so I decided to go back to school. I went back and got LLM in taxation. And so when I took a job at the public defender's office, I worked there for almost about 4.5 years, 5 years, went back into private practice. And that was really a great education for me. You really need to be in private practice to some extent, because then you learn one big thing, driving. Driving's horrible. Like, you gotta drive, you got an appearance in LA, you got an appearance here, you have an appearance there, wherever it might be. So in your county counsel, depending on the nature of your job, you're working at juvie, you just go to juvie, so it's not so bad, right? But if you're working where you're having to defend lawsuits and pursue lawsuits, then you gotta drive and you gotta park. And so I used to park in Skid Row in LA. It was $3 all day. That was so beautiful to me. When I first got to Riverside, I remember seeing there was this big, nice parking garage. It said $2 all day. I'm home. I'm never moving again, right? And so I ended up working in the private practice, and I found out something. I missed my public defender clients. Because some of the people I was working with, they were like millionaires. They were really, really rich. And they had some shady, shady things they were doing. I never used to see anything like this, right? Never seen anything like this, like, wow. Because I was so excited because I learned all these complicated transactions when I got my degree in taxation. So I couldn't wait to get into it. So I never forget we had a case, and this guy, these rich guys. My boss said, yeah, they're good. I was a little leery. And I'll never forget, there were some discovery requests. I said, okay, we're good because this is privileged, so they're not going to get this, and we're going to fight it. But we're in trouble on this because you got these 2 and 3 sets of books. We are in trouble, I'm thinking to myself, right? He said, why are we in trouble? I said, because when the judge orders me to turn it over, I'm going to turn it over. He looks at me, well, why would you do that? Right? This is my first lesson in ethics. Because the judge told me to do so, and because it's the right thing to do. He said, well, I'll tell you what, why don't you just leave the room? When you come back, you'll have what you need to turn it over. I said, no, we're not going to do that. Now, I'm a young lawyer too, right? I said, no, we're not going to do that. We're going to play it right. We're going to go defend this. What the judge says turn over, we're going to turn over. I said, if you don't want me, fire me. And he only had one problem. I had like 50 jury trials behind me. The other senior partner only had 2 jury trials. I had a degree in taxation. I'm representing a tax case. The others didn't. I said, if you want to fire me, just fire me. Right? That was a little bold. My boss might not like that. But there's no way I was going to do that. So they went and they complained to my boss, blah, blah, blah. He said, well, if he's not going to do it, he's just not going to do it. And I really meant it. If you don't want me, then just go ahead and fire me. So that's like my first lesson in ethics. I learned quite a bit. Now, over all these years, believe it or not, I decided to go back to school again and got another LLM. This time I got one in ADR, Alternative Dispute Resolution. And I did it at 58 years old. I must have lost my mind. I had to drive to LA twice a week for 2 years. It was really hard. But my whole attitude's different. Now I want to learn. Right, I'm paying. I want to actually learn. So I learned so much about dispute resolution, and maybe sometime I can come back and talk to you about that. So this whole question of ethics, I always go back to the beginning of my career. And I just learned so much from that initial transaction with those rich guys about what's right and what's wrong. I also learned that he said your word is your bond. I was always told that. What you say has got to be true. And it's just really important that that's the case. And there's so many things over the years I've learned. I learned how you treat people makes all the difference in the world. I'm going to tell you a quick story before we get going here. One of my best friends in the DA's office was a guy named Mike Socchio, a great trial lawyer, a superb trial lawyer. And Mike and I, we had a trial together. It was really a lot of fun. And he did a great job. We both, I think, did a good job on the case and everything. But I would always push him. I'm trying to get the deal. I'm a deputy public defender. I'm trying to get the deal for my client, right? He's trying to hold tight to what he wants. And one day he went I went and told back to my office. I said, that Mike. I said, you know I love him, but he's really getting on my nerves. And the guy said to me, that's funny. He said, you're getting on his nerves. He said, but that Rick, he's so nice. You know, you want to get mad, but you can't get mad. He said, that was so funny at the same time. So there's something about civility that makes a difference. Because you got to go back to the same people time and time again. And if you treat them cordially and respectfully, it's hard for them to be mean to you. If they are, everyone's going to look at them funny. I was in court one day. I was presiding over a case, and I said something, and the lawyer was pretty nasty. And several defense lawyers stood up and said, this is where you say, thank you, Your Honor. They did not like the way he spoke to me, because they liked the way I spoke to everybody else. So you have people even defending you. This civility thing really goes a long way. Let's get going. So this course is a course on what civility is, what it's not, and how to effectively implement your legal practice. And just to make you feel at home, I copied your, right? I like that, Coco. Do you guys call yourself Coco? That is so cool, right? Coco.net. That sounds like something the brothers would say. Right? So I'm going to have to give you some definitions first. And I'm going to say, nobody likes a whole bunch of definitions. I thought civility, how do you teach civility? It's so boring. It's just a whole bunch of rules, right? Civility, what this rule says, this is, but the rules are really important. And I'm going to show you why the rules are important. Those rules later can come to aid you when you really need them. And so we want to look at what the rules are. And there's 2 primary sources I got this from. One is from the ABA Business Journal. An author by the name of Jane Reardon wrote a fantastic article, which I love. And the second one comes from a court case. Can you imagine a court case talking about civility throughout the court case? And I got a whole bunch of court cases I'm going to share with you guys. When you hear them, believe me, you don't want none of that. Right? So there's a couple definitions. 1 star means it comes from attorney Reardon. The other one comes from the case. Civility is the capacity to act in a manner that engenders respect for the law and the profession. You're acting in a way that engenders respect for the profession and respect for the law. And the court said it's an ethical component of professionalism. Civility is part of professionalism. We always say, lawyers, we want to be professional, right? Is that what we all say? Civility is part of it. It absolutely is part of it. And then the court went on to say, civil behavior is a core element of attorney professionalism. We're going to come to see later that has to do with money. Keep that in mind. Now I got you intrigued, huh? How does that civility have to do with money? I'm going to show you. Bam! All right, so we'll start with civility in attorney communications. There's a whole bunch of areas, but I'm just going to focus on the rules that we really deal with mostly. So we have the California Attorney Guidelines of Civility and Professionalism were adopted by the California State Bar. Section 4 deals with attorney communications. And it says, regarding communications regarding the legal system, these words are very important. And the more I look at them, the more I realize just how important they are. Legal systems at all times reflect civility. Okay, that's our first word. Professional integrity. Actually, you really have to think about these words. Personal dignity, because sometimes one of the things you do might be one but not the other. And respect for the legal system. Should not disparage the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not an issue. I thought it was funny it says when those things are not an issue, right? You don't do it, doesn't mean you do it when they are an issue. Well, you do it, but you do it with professional integrity and personal dignity. Because, right, you should not disparage. Well, I'm going to disparage intelligence integrity. Well, sometimes those things are issues. For example, you get a psychological report. When I had a poverty law fellowship, we were trying to show people were psychologically disabled. I had to say my client has a low IQ, but you have to show it respectfully. I once had a client who was testifying, and the judge wondered what I was doing. But I said, the folks who are in court, who are they? He said, they're imposters. They claim they're my parents. And the judge's like, what are you doing? I said, Judge, I have to show psychological disability. I'm showing. This is a chance for you to see. So you have to bring it up, but only when it's an issue, and sometimes, but you still have to do it respectfully. There are times you're going to have things where people make prior and consistent statements, right? So you want to say, in a very nice way, they're not telling the truth, right? So there are times it's an issue, you have to say it. You absolutely do. But it's important you keep in mind you shouldn't do it at all unless it's an issue. And when it's an issue, you always do it respectfully. And now, being 42 years, this is my 42nd year in the practice of law, I can't believe it. I don't know how that happens. When I got admitted to the bar, I was at the Virginia Gap, and it was LA County, it was 400 of us. I was the youngest. I was 23 years old. I was the youngest. And everybody used to say, you're so young, right? I went to federal court to swear in couple friends. I was sponsoring them. And the judge said to me, Counselor, are you old enough to be here? Now, about 5 years down the line, nobody said nothing. I get anything, said, buddy, something now, like that. But now, nobody said that. So you should not disparage another's personal characteristics. You just don't do it. Stay away from it. Sometimes people do. I've heard people say things that are unflattering about somebody's personal characteristics. And I might say something about that. When I was young, it wasn't all that fun to be black. So I'm walking to school, and people would say, there's the N, right? And they'd like chase me. One time I got in my friend's garage just in time. Other times I got beat up on my way to school. I'm kind of sensitive about personal characteristics. And more recently, I was in my own neighborhood. I was about 62 years old at the time. I was walking at night, and I always walk and read. Some of you have probably seen me do it. I walk around the whole court system reading, because that's what I do, walk and read. I get my steps, right? Got my little Fitbit watch. And I read, I think about it. When I get back, I summarize what I wrote. Well, I just sit at my desk for because I read about 5 hours a day, but I just sit at my desk. If I get up, I feel nothing but joy. So I walk and I read. So I'm at night, and I'm walking, I'm reading. Sometimes listen to music, contemplating. And so all of a sudden, this guy in this truck pulls up by me. He looks, he says, you okay? I'm thinking my house, right? I'm fine. I want to say, are you okay? Right? He said, you okay? I said, I'm fine. He said, the boy said you were chasing him. I'm saying, chasing who? I'm 62 years old, I got my bad hip. I'm out here reading, minding my own business. What are you talking about? Where do you live? I said, I live right there, like right across the street. And we all got Ring cameras, by the way. I said, I ain't chasing nobody. I said, if I'm walking down the street, if somebody happens to walk, and I'll tell you, because of personal characteristics, because I'm black, there have been times, if I'm walking down the street and somebody else walking, I will literally, during COVID, I'm always the one that walked onto the street and let them stay on the sidewalk. If I'm walking, even if I see a person I'm coming up on because I was walking kind of fast, I always be the one that will go around just to be careful. So I don't know what this guy's talking about, right? So I have no idea what you're talking about. This is my neighborhood. I live right there across the street, and I'm just walking my neighborhood. And I was thinking, is that how people get hurt? I mean, is this how we hear about the story in Atlanta, right? Personal characteristics. You just see me, I'm walking down the street, some black guy walking down the street, you have no idea. I have to say, that kind of hurt my feelings. I've been called everything before, you know, especially as a judge. One guy once said, "You tell that judge he can kiss my ass." I said, "You tell that judge I respectfully decline." I said, "You tell the gentleman I respectfully decline." Right? So I've been called everything. That stuff doesn't hurt my feelings. I'm used to that. It's the nature of the business. But that kind of hurt my feelings. I'm just walking down the street minding my own business. So I'm sensitive, and I would really urge you, don't just leave personal characteristics out of it. Sometimes people like to use the F word. Did my mic go off? Yeah. Okay. I'm too animated. Okay, maybe you can.
This fell off your.
Okay, this will get me hooked back up there.
Yeah, fix that really quick. I'll edit this out. All right.
Okay, thank you. All right, so now, you should not make exaggerated, false, or misleading statements to the media while representing a party in a pending matter. I personally heard that. I've heard people go out and say, "I've seen indisputable evidence that blah, 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 blah," and it wasn't true. I heard the person say, "There's indisputable evidence," and it all came out there wasn't one scintilla of evidence. It actually happens. That's a misrepresentation and a violation of this rule. You should avoid hostile. I think that's number one, demeaning or humiliating words. I've seen mostly hostility. People get mad, you know, especially your DA, public defender, maybe your county counsel, and you're dealing with parents' counsel or whatever it might be. Sometimes it gets really hostile. Would you all agree? Sometimes people really get mad, right? Just should not be hostile, demeaning, or humiliating words. Should not create a false or misleading record of events or attribute to an opposing counsel position not taken. I'm sensitive on this one too because I spend 5 hours a day reading. So I read the opening brief and I said, "Ooh, that sounds pretty good." Then I read the respondent's brief. "Hot dog, didn't even say this, and they didn't say that, and they didn't say this, and they didn't say..." It's kind of, I can't believe it. That does not leave a good impression, right? And I want you guys just to think about that. Put it all out there, because it is what it is, and the decision should be based on all the facts. Wouldn't you agree? It should be. So I'm not trying to hide anything. Should agree to reasonable requests in the interest of efficiency and economy, including a waiver of procedural formalities. In criminal, very typically, we say, waive formal arrangement and advisement of rights, right? We don't go through all of that stuff every time. It's just common, right? Or someone comes and says, we get requests all the time at the court. "My wife's having surgery on this day. Can I continue the oral argument?" Of course. And sometimes it's been continued more than we want. I kind of don't want to, but those kind of things, it's a reasonable request. The answer is always yes, if it's a reasonable request. And you should do the same. Now, let's look at some examples of attorney communications. And these are basically my own examples. This is how I speak in court. I never, ever, ever call a person a liar. You want to start a fight, just call a person a liar. Boom, you're a liar. Boom, then boom, you got it, right? What we used to say, it's on and popping, right? As soon as you call a person a liar, it's on and popping, right? I would say, "Your Honor, it's simply not true." Right, Your Honor? Doesn't that sound much better? It's simply not true because the record shows this, and I have these reports that show this, this, and this, and the witness testified previously to this. So without saying a liar, I said the exact same thing, very politely, very respectfully. There's a way to do it. People say, "Well, what do you mean civility?" There's a way to do it. It's no big secret. There's nothing magic about it. "You're a liar." I love saying, "I'm sorry, the gentleman lacks credibility." Right? And I've said that on many occasions. "I'm sorry, that lacks credibility." What a great record, right? "The judge is rude." The judge was not rude. The judge said it lacked credibility. That's the court's determination to make. You can say it too. "Your Honor, that lacks credibility." In your case, since you're advocate, you might say, "Your Honor, respectfully, I believe that's not true because," or you can even say that's utterly lacking in credibility. Although, by the way, many times I take out the word utterly in our opinions because it's a little strong. So sometimes I say it lacks credibility because. So that's just a great way, and I've said that on many occasions. One time I heard something that was really hard to believe. It was really hard to believe, like, you gotta be kidding. Because in my world, we grew up, we speak in the vernacular. Like, you say something ridiculous, and look, you tell that to somebody else, I've been to school, right? But of course, I can't say that from the bench, right? I've been to school, tell that to somebody else. And of course, we're not talking about school with book school, right? But instead of saying that's stupid, because you're thinking, that's the dumbest thing I ever heard, right? How many of you heard things you thought it was the dumbest thing you ever heard? All right? You think, that is the dumbest, I can't believe, you're thinking, I can't believe the person said that. That's the dumbest thing I've ever heard. When I would hear that in court, I just say, I'm sorry, that's unacceptable. My dog got it, ran out the door, gave it to, whatever it might be. And I said, I'm sorry, that's unacceptable. Or, sir, you missed court 52 times. But, Your Honor, I was a little tired. You're thinking, I was actually doing a jury trial. I was representing a client in a jury trial. And I know your prior speaker will appreciate this. And so the court was in front of the trial was in front of Judge Hanks. Never forget. So we were supposed to come back in the afternoon session. The jury's here, everybody's there, we're all here, my client's not here, right? So I called the client, where you at? He's at home in Banning watching cartoons. Now, if that's not the dumbest thing I ever heard, right? Are you kidding? And I have to go in front of the judge and say something, right? So that's not acceptable. So if somebody came to me and said that, Your Honor, he's at home watching cartoons, I'd say, I'm sorry, that's just unacceptable, right? Just leave it at that. So I want you to know there is a way to do it. And these are all my own examples. We were passing an opinion around. So if you're the author, you write the opinion. If you're on the panel, you review the opinion. When it comes through, say if you agree or don't agree, and we always write comments, whether we agree or don't agree. Sometimes what we don't agree on is language. And I don't like harshness. I don't like harshness in opinion. So we got one that came across, and it got to me, and it said, that is incoherent, the argument. Now, you imagine, you're the lawyer, and you get something from the appellate court back to say what you said was incoherent. Let me ask you, how many of them, would that hurt your feelings? Would that hurt your feelings if you got something, honestly, how many would that hurt your feelings? Yeah, that would hurt that made me cry like a baby, right? So I said, no, I'm not gonna sign it. I'm not gonna sign it. We're calling the lawyer's argument incoherent. Although, was it incoherent? It was. It was. So I said, no, that's unacceptable. I said, you know what, can't we just say it's unclear to us? Or I'm sorry, we don't understand. Well, I finally said, you know what? I settled on the language, it's logically inconsistent. Doesn't that sound better? So literally, we have an opinion out there, don't go look it up, where I took out the word that my colleague had written incoherent and wrote logically inconsistent. And we all agreed upon that. And we usually do agree upon that, because sometimes when you're writing it, you're into it, and so sometimes it's very helpful to have somebody else look over what you're writing and what you're saying. If you have a question, just ask somebody to look at it. We have the advantage with 3-judge panels. We always look at it. So I said, okay, it's logically consistent. And the other thing I don't ever do is I never say you're wrong. Because you might be right. Supreme Court might reverse me. So I never say you're wrong. That's pretty arrogant to say you're wrong. Because you might be wrong, right? So what I always say is this. Especially when we're reviewing a case from another panel. They said this and we're saying something different, right? I never say you're wrong. I said, our colleagues in Division 2 said, or wherever it might be, Second Appellate District said blah, blah, blah. In our view, that's all I say is in our view, respectfully, we see it differently. In our view, we see it this way. Whatever, ever one time saying you're wrong, but obviously that's the implication, right? We say it differently. So I always say in our view, and the funny thing is one of our research attorneys said, oh, I'm glad to know that, I said, you don't have to say a person's wrong. You say, even when let's say you're in court and somebody argues something, Your Honor, I understand that's their position. But in our view, or respectfully, we don't agree with that. In our view, this is how we see it, and say it that way. And the last thing I want to say on this, it's not the last thing, but one of many things. I was doing a case once, and I had a suppression motion. I heard about suppression motions earlier. And I was doing a suppression motion, and I won it. It's a 1538.5 motion, I won it. So of course, I'm very happy. So part of civility is you don't get happy in court, right? You win the motion, you just keep just like nothing, But the DA came up to me, tapped me on the leg and said, nice job, you hit all the issues. Why can't we do that? Why can't we just say, you did a good job, right? It's a good thing he said that, because 2 weeks later he kicked my behind in trial. He did, he tore me up. And the nice thing is I was able to say, man, you really did a great job, right? Why can't it be that way? And it really should be that way. So you might just surprise yourself, you might surprise the other side. Sometimes you just say, nice job, you get all the issues. Now let's talk about punctuality. You should be punctual in appearing at trials, hearings, meetings, depositions, scheduled appearances. I'll never forget, I've only been late one time my whole career, 42 years, one time. I was going to LA, there's that driving again. I was going to LA and there was a SIG alert. It was the early 1980s, and of course back then there were no cell phones. So SIG alert, what are you doing? I'm sitting on top of my car, my 1978 Toyota Corolla SR5 liftback, right? Sitting on my car, can't believe it. I can't believe it. I left my house at 5 o'clock for an 8:30 appearance, and I'm not gonna get there. I'm dying. This is torture. This is not fun, almost like the prior speaker was saying. Sometimes you're dealing with things that just aren't fun. I can't believe it. I'm not gonna get there. So finally, after a couple of hours, I got off the freeway. I'm gonna call the courtroom in LA from a pay booth. Do you guys know what a pay booth is? from a pay booth, right? Can you believe this? So I got on the phone, somehow, through a whole bunch of machinations, got a call in and found a courtroom somehow. It didn't matter. So I get to the court, we already called your case, we issued OSC. I've never been in trouble before. I'm a brand new lawyer, I'm scared. So I had to go literally get all the information, had to show there was a SIG alert, freeway was shut down, I called LA, I called the court, did all I could possibly do. I'll never forget the judge says, I'm not gonna sanction you this time. I said, thank you, Your Honor. No, I said, oh, thank you very much, Your Honor. But to myself, I said, thank you, Your Honor. You know? So I said, I'm never gonna be that way. I said, I'm never, ever, ever gonna be that way. But you should be punctual. That's the only time I've ever been late. Now, more recently, I had a speaking engagement in the morning, and it was over the noon hour. No, it was in the morning. It was in the morning. So I had a court at 8:30. If you know me, I'm hovering. 8:25, I'm ready to go. I'm waiting to go out there. Can't wait, right? I'm just excited. So here it is. I have a speaking engagement. So I made that engagement, and I'm driving towards the courthouse. So I passed the DA's office. It was about 8:20, and the DA said, he's going to be late. He's going to be late. The DA got excited, right? When he came in, they opened the doors of the court, and I was on the bench. He could not believe it. I got in there, ran up the stairs, got on the bench right on time. That was my only other close call. But I had an excuse. You should be punctual. You should arrive sufficiently in advance to resolve preliminary matters. This is very frustrating for courts because many times, I've had times where I'm doing a trial, I'm presiding over a trial, and so I come out, and every time I come out, it's 1:30, the jury's there, we're ready to get started. You're gonna waste a matter we need to bring to the court's attention. Now the jury's mad. They already had an hour and a half, they've been off for lunch, and they are mad. But I don't get to say, counsel just told me something. I don't get to say that, right? So it's really not good to do that. It's really, if you got preliminary matters, you need to arrive sufficiently early. Your Honor, can we come at 1 o'clock? Or can we have the jury come back at 1:50? Because we have some preliminary matters we need to take up. There was one court case I was doing, it happened so much, I was like this. Open my head, look out the court, is it safe to come out? Is it even safe to come? Because every time I open that door, they say, Your Honor, we have something we want to bring up. Every single time, really? So it's really important that you arrive sufficiently to take care of these things. And notify the participants when you're going to be late. When I went from criminal to civil, it was amazing to me because criminal is so lax. Civil so strict. Civil, right on the bench, 8:30, start calling matters, right? Criminal folks walk in, typically, sometimes, at 5 minutes to 12, demanding priority. Literally, 5 minutes to 12, I need priority. Counsel, I've been here all day. Where you been, So I go to civil, and the lawyers are all nervous. So I actually get a call in from the lawyer. He said, I'm outside, I'm parking right now. It almost made me laugh. You're fine. Don't worry. It's all good, But if you notify the court or notify the opposing counsel you're going to be late, because what if they come at 8 o'clock or 8:30 and you don't even get there to 10:30? They could have done other things. So you need to be respectful of other people's time. And I have very, very few pet peeves, like very, very, very few. One of them I do have, though, is not notifying the court when you resolve your case. Because I'm going to give you 110%. I am. I read every word of every brief. Always. I'm going to give you 110%. So I had a 995 motion, a motion to set aside the information. And I remember I had it, okay, it's on for the next day. I'm in trial, so I didn't get a chance to look at it. So I'm going to take it home tonight, separate myself from my family, go read the transcripts, read all the briefs, make a tentative ruling. That's what I'm going to do. And that's what I did. Next when I come out, get ready to get my tentative ruling. Your Honor, that matter's been resolved. We talked about it last week, we resolved it. I thought, well, that's very disrespectful. I went home. I told my family I can't hang out with you because I need to read your papers. And nobody even told me. So after that, they all got the message. I guess I communicated it pretty well. Like, could you give me the respect of letting me know so I wouldn't take the time to do that? So make sure you notify the court when you resolve the case, particularly not the Court of Appeal. And I know sometimes it's tough, but we put so much time into those cases reviewing them and then writing out those opinions, and they get circulated, and sometimes a second time and a third time. If you've already settled the case 3 weeks before, boy, that's very frustrating. And that's just a real aspect of civility. Now, this is one of the aspects, and that's why you guys have these PowerPoints. This is one of the aspects that should help you. Because sometimes the clients don't want to be civil. We see it in family law all the time. When I was presiding judge, I felt sorry for the family law judges. They get all the complaints. Just constant complaints. And sometimes the pro pers are complaining a lot. And so if you have a client, and especially if you're doing juvie, your county counsel doing juvie, a lot of times there's Marsden hearings, right? But you get to, the rules say this: you should advise your client that civility and courtesy in scheduling meetings, hearings, and discovery are expected as professional conduct. So when you have a Marsden hearing, because the lawyer say the client saying you're not representing me properly because you agreed to continuance, you tell the judge at your Marsden hearing, Your Honor, under Section 6 of the Attorney Guidelines, I'm required to advise my client that civility and courtesy in scheduling meetings, hearings, and discovery are expected as part of professional conduct. You think that would help you? All of you? Do you think that would help? You bet it really will help you. It's not just a matter of, I'm just doing it willy-nilly. The rules say this is part of professional conduct. I'm just doing what's required. It's a reasonable request. I'm required to do this. I would absolutely cite this rule if I had a Marsden hearing. And a Marsden hearing, for those of you who don't, you all know what a Marsden is? I assume you all do. Yeah, okay. That's for the client saying that you're not representing them properly. And so, consistent with existing law and court orders, the rules also say attorneys should agree to reasonable requests for extension of time that are not adverse to a client's interests. So the person tells you, I need a 5-day continuance because my wife's having surgery. I need a continuance because my kid, is in trouble at school, whatever it might be, just a reasonable request. That's to be expected, and you should do it, and the rules say you should do it. Now, part of the problem we have in criminal is counsel, this case been continued 32 times. I'll never forget this. And once the lawyer said to me, he said, Your Honor, you need a continuance. I said, no, counsel, not continued. It's been continued like 32 times, like some ridiculous number. He said, well, this is a life case. That sounds real good if you don't have any experience. But if you have a little experience, you see it was a 3 strikes case. It's just a regular burglary. It's a 4-day trial. It's a regular burglary, and you add the strikes, and that makes it life. I said, counsel, you've done 500 burglary cases. The DA's done 500, and I've done 500. This is just a regular burglary case. It doesn't take 32 continuances. It says, well, fine. It says, my client's going to be denied effective assistance of counsel. But that's fine. You're welcome to go to court of appeal and tell them that 32 continuances was not enough. they respectfully decline to do that, right? Oh, okay, we'll proceed. So you have the good record. You have everything in your court if you have a good record and if you're appropriate and civil. Now check this out. Benefits of civility. Oh my goodness, I said civility has to do with money. How so? Well, this Carton case tells us how so. It says, excellent lawyers deserve higher fees. We like that, right? Excellent lawyers deserve higher fees. Excellent lawyers are civil. The court case said excellent lawyers are civil. What do you guys think about it? Is that pretty cool? Excellent lawyers are civil. So when someone's not civil, I would not call them an excellent lawyer. I would not. Attorney skill is what courts look at in deciding whether to adjust a lodestar, the fees you get. And then the court said civility is an aspect of skill. Civility is an aspect. So if you're civil throughout the process, chances are you can get higher fees versus not. So the case example is this Carton case, and you have the site there. The lawyers are asking for $270,000 in fees. The trial court only awarded $90,000. The appellate court noted the trial court's comments. Said Carton's counsel's briefing was replete with attacks on defense counsel. We already learned that's no good. Attacks on defense counsel, right? Defense counsel filed knowingly false claims of witness tampering. Defense counsel's comments were frivolous. Something was typical of the improper tactics employed by defendants and their counsel. The trial court said the attacks were really offensive to it. The trial court did not like all those attacks in the papers on the counsel. Why not just stick to the issues? Why do you have to start talking about counsel, right? The court gave Cartons a 10-page limit for supplemental briefing, but they filed 300 pages of documents. The court says 10 pages, please don't give 300. Right, maybe you did 11, we won't look askance, but if you get 300 when the court said 10, you're in trouble, right? And the court said lots of extraneous documentation. And the court said this: if this is reflective of the litigation that went on in this relatively simple sounding case, I understand how you and your counsel may have spent the number of hours that you spent. Right? I'm not going to give it because your incivility is what caused so many hours. I know why it cost so much. And the court went on to say that they went so far beyond what was necessary in this matter. The appellate court agreed and left the fees at $90,000. They billed $270,000. They claimed $270,000. The court said, no, you're going to get $90,000 and we're going to leave it at that. Civility is socially advantageous. It lowers the cost of dispute resolution. We certainly know that. Civility tends to be efficient by allowing disputants to focus on core disagreements and minimize tangential distractions. I'm going to give you an example. I had 2 trials back to back. First one was a petty theft. The second was a special circumstance murder case. The petty theft had very new lawyers, very, very new lawyers. The one lawyer from the defense side was so terrible, that pretty soon the word got out and we had about 18 DAs and maybe 13 or 14 defense attorneys came to watch. This is how terrible it was. And literally, the word got out. And literally, every other word, objection, 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 objection. You think it's a petty theft. You can't believe it, right? Oh, my head was just pounding. I think, how could this be? This is like my most difficult trial ever. It's a petty theft, right? My head was just hurting so bad, right? And then so the lawyer, she had her notes, and her notes spilled all over the floor, right? And I said, counsel, I said, why don't you just put your notes on the podium? I said, just put them on the podium. You can walk away from the podium, just like I'm doing now. You can walk away from the podium, do whatever you want, and just go back to your notes and pick up what you want to pick up, right? No, Your Honor. I said, okay, just a recommendation. So she saw that she drops her notes again in front of the jury, all over the floor, handwritten, right, just before all the technology. So she's there picking up, and of course you're trying to sort it out. Can you imagine in front of the jury? Page 1, this page 2, page 3, right? Then she dropped them again a third time. I called her aside. I said, I'm really going to insist that you put your notes on that podium because this is getting embarrassing. And she just, next thing I know, the top persons were there from the respective offices. It was so bad. It was so bad. And it wasn't efficient at all. And there was an objection to every single question. They weren't focusing on the core issues. I followed it up by a special circumstance murder trial. You get the best of the best lawyers. You get the best of the best. Maybe 5 objections the whole trial. Special circumstance murder trial. 5, 10 objections. Just so focused in, just so skilled, so talented, so unbelievable. I'm like, can I have another one of these? Right? Can you keep the petty? I'll tell you what, you keep the petty theft, I'll do the special circumstance murder trial. It makes all of it very efficient, got through it amazingly well. So having seen it in person, I can tell you it's really true. I said, lawyers who behave with civility also report higher personal and professional rewards. And we heard your prior speaker talking about, I heard him talking about sometimes the tension you have. It just makes it miserable, the practice of law. And research shows superior service, including relationship, increases client retention rates. But now, what is civility? What it's not? It doesn't mean the absence of disagreement. You're still going to disagree. The civility codes are premised on the assumption that people are going to disagree. If people didn't disagree, we wouldn't have a legal system, right? It'd be like nothing to it. I always say this. Imagine a legal system. You guys are county counsel, where all the parents came in and said, you're right, your recommendations are perfect. Right? Wake up, right? That doesn't happen, right? You're going to have disagreement. Or the DPSS comes in and says, you're right, we're sorry to have interfered with your lives. We're just so sorry. We don't know what we did. We don't know what we were thinking, right? It's not going to happen. So civility is not the same as agreement. That's pretty clear, isn't it? It's not the absence of criticism, right? When addressing a court, sometimes people want to show we're wrong. And frankly, we write a tentative opinion. I've written it, looked over everything. I have 3 research attorneys. It goes gone to the other 2 justices. They looked at it. So what I usually ask is, what I'm really looking at, well, of course we think we're not going to send something out we think is wrong. We think it's right. right? We think it's right. We're not going to send it out because we think it's wrong. So what I'm looking is, can you show me I'm wrong? Can you show me what is it specifically that you think is wrong in the opinion? So one of our justices will say, what do you think we got wrong? I don't usually say it that way. I'm usually just listening to see what the person has to say. Or what about this particular issue? Or sometimes I ask very specific questions. What about? Because you said this and I've given you other authority. What about this particular issue, right? So you have to address the court. So you might just say, Your Honor, respectfully, I believe the court is in error on this. That doesn't hurt my feelings at all, right? And you tell me why. Respectfully, I think the court is wrong on this because, and I'm going to look, and you give me something to look up, I'll always go look up. When I was in Superior Court, someone would say something, I said, well, let me go off the bench. Go look up your case, read it, come back, make an analogy, and say yes or no. And so no problem at all, right? So that's one way to do it. The other way is we had a pro per recently. He was in court, and he said this, whoever wrote this opinion should be ashamed of themselves. Well, that was me. So I'm not going to say it hurt my feelings. It kind of made me smile, but that wasn't very respectful, huh? And that's not going to get you a long way with the court. That's not a way to persuade the court. Whoever wrote this opinion should be ashamed of themselves. Well, that's just not persuasive. So that was kind of funny to sit there and hear that and not smile. So a law firm partner, and this is actually one of the authors said this, law firm partner doesn't correct a young lawyer's brief isn't being civil. So you get a brief, you're the supervisor, you don't correct, that's not being civil. You're just not doing your job, right? Or you're county counsel, and you have deputies, and you see errors, and you don't correct them, that's not being civil. You're just not helping, you're not doing your job, you're not helping them. So civility is not the absence of criticism. Sometimes you have to say, yeah, that's not the right way to do it. You need to do it this way or that way. Now I'm just going to tell you something. My least favorite term with a non-smiley face, right, is with all due respect. We had one DA used to say it, Your Honor, with all due respect. There's something about that word, that phrase. You can never just say, Your Honor, with all due respect. It never comes out that way. With all due respect. Right? That's the least respectful statement you can ever make. I'm telling you. As soon as a person says that, that's what's like, because you know they do not mean you any respect on that. So just think, just a slight change. If you said to me, Your Honor, respectfully, that would be perfectly acceptable to me. Respectfully, this is how we see it. That doesn't faze me at all. But as soon as the person says, all due respect, now you all know my secret. As soon as you hear somebody say it, you're going to think, he's not liking that. And you'll be right. So I would urge you not to use that term with all due respect. I know some phrase we just say a certain way. And somehow that phrase just gets said a certain way. And I can see one lawyer, even when it wasn't me, it was somebody else, Your Honor, with all due respect. And I see it sometimes on TV, I hear it said. It's never said politely. It's always said in a way like contemptuously, you know, like I'm not loving it. Okay, civility is not the same as liking someone. We have to show respect for everyone in our space. I think in a small town it's easier because like in Riverside, you see the same people over and over and over. When I was in LA, it wasn't so. You only see the person one time, and I found people were much harsher when I was in Los Angeles than they are here because they don't necessarily see the same people. Reardon, the author, said that she thinks that that's a myth, that small communities, that it's nicer. Personally, I've seen otherwise. I just give you that to let you know somebody thinks otherwise. But I see in our community where you're seeing the same people over and over and over, you treat them disrespectfully, they're going to be back the next day. They're going to know that. They're going to see you, and they're going to respond accordingly. Examples of things, people you don't necessarily like, but you have to be respectful. I had a KKK appearing in my court for a preliminary hearing. It was a racial hatred crime. Can you imagine? I was the only black judge at the time. Only one black judge, you get a racial hatred crime. Here I come out. You know, I want to say, surprise! Right? Can you imagine? It's a racial hatred crime, right? But you know what? I still sustain my objections. I still call them ma'am and sir. If the objection is good, I sustain it. If it's bad, I overrule it. Nothing changed whatsoever. The respect is still there. I once had a KKK as a client when I was a young public defender. I said to him, you don't like this? He said, no, I don't like it. So I went downstairs in the courthouse and found Richard Siegel. And the guy had a jacket that said Knights of the Hidden Empire. I said, Sieg, I got this guy up there, he got a problem with this. And Sieg says, hey man, he's not gonna want me. Right, he was Jewish. He's like, he's not gonna want me. I said, Sieg, he'll never know. He'll never know. So Siegel came up, asked him, Richard Siegel, a lawyer. He came up, got the guy's case, and the guy said, yeah. He said, yeah, you look very Italian. Sieg said, yeah. Right? And they said, oh, see, he worked out a deal. The guy walked up there and pled guilty and walked out. Never knowing he had a Jewish lawyer. So we still treat him with respect. My colleague, Justice Codrington, had a white supremacist in her courtroom who ended up really, really liking her a lot, and made it known. We had a super aggressive constitutionalist, one of the nastiest guys I've ever come across. I kept trying to tell him, sir, I would urge you, please consider this offer, please consider it. And he wouldn't, it's everything, objection, everything. He had all the constitutionalist language, so it didn't matter what I said. He had some, it's maritime law and all the stuff they say. It just, you have no jurisdiction, you spell my name, the first letter should be small, it's all that. And he ended up getting like 87 years. He had a chance to get 4. I said, sir, I've been doing this a while. I can't tell you what to do, but I urge you to consider. He did not listen. But he ended up getting like 87 years. And I had a case where the defendant punched the DA during trial. I did not love him. He jumped up right during trial and he punched the DA. So what I did what the law requires, and only what the law requires, minimum restrictions. So I handcuffed him. You have to show manifest need. Well, that was manifest need. Then he jumped up again. So then I leg chained him. All in front of the jury, right? And then he punched the DA right in front of the jury and made a motion for a mistrial. Went back off the bench, looked up some cases, said you can't create your own mistrial by your misconduct. Motion for mistrial is denied, right? Then he jumped up again, so I had his feet shackled. Then he jumped up again. I said, okay, the gentleman was removed from the courtroom. Just respectful and minimal. So that's when I said, you're excluded from the courtroom, we're gonna do the trial without you. Wonderful day of trial. Wonderful day of trial. So we do the trial, it's wonderful. And then the next day I send the deputies down with cameras. The judge said, will you behave? If you can, you're welcome to come back to court. You tell that judge to kiss my A. They came back and said, Your Honor, he said, you may kiss his A. That's the time I said, you tell the gentleman I respectfully decline. And then so the next day, same thing. But you see how the tone makes all the difference, right? On appeal, no problem at all. 0 problem. Next day, same thing happened. Third day, I tell the gentleman it's the last day of his trial. If he wants to come, he's welcome, but he has to behave himself. Okay. He came back up and we finished his trial up with him there. So it doesn't mean, civility doesn't mean liking somebody. And it should not be equated with politeness. Politeness is, of course, part of it, but good manners are not enough. And the example is given by Attorney Reardon is politely refusing to serve someone is not civil, right? Or politely refusing to hire somebody is not showing civility because of their gender. Now, incivility can rankle relations and thereby increase friction and the cost of litigation. This is my favorite phrase I've seen in a case. It says, calling opposing counsel a liar. This is my favorite phrase. My favorite word in English language is vicissitudes. I heard it from Howard Cosell. My favorite word in a court case is, calling opposing counsel a liar can invite destructive reciprocity. Is that like a great phrase, right? And generate needless controversies. So again, I respectfully agree with counsel's recitation of facts is probably better than calling a person a liar. But the court case said it can cause destructive reciprocity. It can adding minor irritants into disagreement can turn a minor conflict into a costly and protracted war. And everyone loses, including the justice system, which must supervise hostilities. Amen. And I just want to say this, and your prior speaker talked about this. 95% say incivility makes the practice of law less satisfying. And you all know it. You all know it instinctively. You feel it when you're in court. And of course, kind of like the prior speaker was saying, lawyers are 2 times likely as the general population to suffer from mental illness and substance abuse. Uncivil behavior adds to that needless stress. Now let's look at some hypos. Typically, this only comes up in the context of contempt. Because usually just bad behavior, right? Nothing happens unless the judge cites the person for contempt. So we're going to have some fun. You and me, we're going to have some fun. Okay, the lawyer tells the jury they would be instructed to return a just and lawful verdict, but just means a fair trial. And Mr. D has not received a fair trial in this case. Is that contemptuous? What do you think? Contemptuous? Yes. The court said it was contemptuous on its face because it impugned the judge's integrity by suggesting he failed in his duty to guarantee a fair trial. So if you get up in front of a judge and say, you're not getting a fair trial here, you're impugning the judge's integrity, right? The court said it constituted disorderly, contemptuous, or insolent behavior towards a judge while holding court, tend to interrupt the due course of trial or other judicial proceedings. Bam. Hansen versus Superior Court. Now, during closing argument, defense counsel says, it's the goal of the prosecution to misrepresent the facts. That's kind of a fun one. I got a little extra on that one. I got a little bonus package on that one for you. I went and followed up with that again. She said this: the goal of the prosecution is to represent facts in a way to their side. Defense attorneys do it. I do it in this case. We all do it. That's our job, to misrepresent the facts, right? He says, you should never trust any attorney for what they say because they're paid, just like I'm paid to misrepresent the truth to you. So you guys might think this civility stuff is like made up. This is real. This is like a real case, published case, right? Contemptuous? What do y'all think? Absolutely. A court may hold an attorney in contempt for willful violation of a duty. An attorney has the duty to maintain respect for the courts, judicial officers, and to abstain from all offensive personality and not to mislead the judge or jury by artifice or false statement. Yes, even though it was not directed to the judge, it was absolutely contemptuous because the attorney did not maintain their duty. They violated their duties. The attorney violated these duties by arguing to the jury it was the goal of the DA to misrepresent, and the defense to misrepresent the facts. Lawyer says, Your Honor, I submit this trial is becoming a joke. Contemptuous? What do you think? Contemptuous? I hate to be wishy-washy, but this one is wishy-washy. That's not wishy-washy, it's pretty clear. Contemptuous? No, it was not in this case, but could be. The court said the conduct was not contemptuous on its face because it did not refer to judicial conduct, much less judicial nefariousness. They're not really saying anything bad about the judge or imputing the judge's integrity. What the court said was, the order of judging contempt did not declare that the statement made an accusation against the judge. In context, a witness ran away with a narrative, and even the DA tried to get him stopped. How many of you have a witness that goes off and you trying to stop him? Stop, your own witness. Especially if the court gave an in limine motion, your client's still going, stop, your witness. You're trying to get him to stop. And so the court, so in context, it wasn't directed to the court. You could see a lawyer just saying, this is a joke, right? You're not imputing the judge. You ask the question, the witness won't stop talking. So the court said, no, they didn't find that to be contemptuous. Oh, this is a good one. And you'll see the same thing over and over. Lawyer says, this court obviously doesn't want to apply the law. Contemptuous? Yes. Don't ever say that. Almost all these cases, there's something similar to that, right? The court said yes. The court said the attorney's statement constituted an attack on the integrity of the court. The statement fairly read means, as indeed the trial judge took it to mean, that the judge knew the law but deliberately chose to ignore it. Attorney got 5 days in jail and $500 fine. Upheld. And note this, the court's power to punish contempt, an act which impugns its integrity, exists independent of the statute. So most of the contempt has to do with the statute, but the court has an inherent power to do it. I want to make sure you know that. Next hypo. Okay, court says, you're interrupting. Don't do that. Lawyer says, you're just making up the facts. Not good, huh? Contemptuous, everybody? Yes. Court said this. How would you like to have this published about you? In our collective 97 years in the legal profession, we have seldom seen such unprofessional, offensive, and contemptuous conduct by an attorney in a court of law. How would you like that written about you? In our 97 years of collective practice, we've never seen such terrible behavior. Woo! No. What else did she say to get that comment from the appellate court? She said this, you must realize intellectual dishonesty is appalling to me, to the court. And to hear the court paraphrasing testimony in a way that is less than complete and a complete aberration of what was testified to. Judge says, I was making a ruling and you interrupted me again. Lawyer says, but you're wrong. You can't believe this is happening to you. In case you feel like you're the only one who ever experienced an out-of-line lawyer, the appellate court called this the trial from hell. In the opinion, right? The trial judge acted appropriately and commendably, and attempting to restrain an attorney who was out of control. That's what you want written about you. You were controlled and you were commendable. All right, next hypo. The lawyer says to the Court of Appeal in an appellate brief, now you're my world, right? After reading the opinion, it became painfully obvious this court worked backwards to ensure that the ends justify the means. It is clear from the opinion this court neither reviewed the controlling cases nor read B's reply brief, which contained the authority mandating reversal. And why would this court look at the case decided by B anyhow, when it's concealed its own conflicts with defendants resulting from their prior relationships? All this impugning the integrity of the court is what it really comes down to, right? Contemptuous, everybody? Yes. Court said the attorney accused the court of deliberate judicial dishonesty. There you go again. Just be careful with that, right? Attorney got $2,000 fine for 2 counts and reported to the State Bar of California. Next one. Lawyer in appellate petition said, instead of demonstrating a neutral posture, the court bent over backwards to come to the aid of a fallen comrade, which is the San Juan district attorney. Contemptuous? Yes. Court said it's contemptuous for an attorney to say or imply that the court knows the law, but has deliberately chosen not to follow it. It actually happened in Riverside County, and I actually saw it, and the judge cited the lawyer for contempt, and the judge gave him 2 days in jail or a $100 fine. The lawyer said, I'll take jail. So he went to jail, and after the 2 days in jail, he regretted it. He wished he paid the $100 fine. Okay, hypo 8. Court sustains DA's objection during closing argument. Counsel argues the same thing. How many of you have been there? Court sustains objection, they argue the same thing. You ever seen that? Raise your hand. Right? Court says, on this issue, move on. And the counsel says, have any of you ever says, I will not move on? Right? Until you haul me away. Don't beg the court to put you in jail. This is the most important issue of the case, and you're not going to convict my client. Counsel also says, you're not my mother. Why not? You're already in trouble, right? Contemptuous, yes. Okay, so we're going to conclude with this. I want to give you an example because when we talk about civility, some of the stuff sounds outrageous. But then you see in the actual published cases, it happens. We don't want to do it. And we particularly don't want to impugn the integrity of the court. And the other aspect of it is we treat people with respect, we're going to get respect. I'm going to conclude by telling you just a quick story, and I'm going to read this conclusion to you. And that was Judge Michelle Levine and I were both lawyers at the same time. We tried a case together. And it seemed to go so well for me. And Judge Levine, she's just a great DA, great lawyer, fantastic person, great lawyer. So and everything seemed like it was going my way. I was cross-examining the witness. Everything I could want was coming out, right? The jury had a question. We went back over to get the jury question. It was favorable to me. She looked. And the jury foreperson, during Judge Levine's closing arguments, at the time she was DA, was going like this. If you don't believe me, ask Michelle Levine about it. Right? So we finished the trial, and the judge called her up and said, Ms. Levine, if you get one person, it's going to be a miracle. The jury comes out, verdict. We go over, right? I'm standing there, guilty. I could not believe it. I could not believe it. Like, oh, you have your whole heart and soul poured into the case. But from that, Judge Levine and I became really dear friends. So instead of becoming hostile towards one another, really, really dear friends. Well, later I got on the bench, I'm a judge. She's applying for judge, and she comes to me and says, will you support me? I said, of course I'll support you. I'll write a letter for you. And I sat down and wrote a letter for her right then, saying this is the best of the best. You need to appoint her right away. And she got appointed judge. Well, later when I applied to the appellate court, and I went up to tell her, I said, Michelle, I just want to let you know, we were colleagues, so it was so fun. I said, just want to let you know, I'm applying to the appellate court. And she went to her computer, sat down, and she says, I got something for you. And print out a letter. She'd already written a letter to support my application even before I did it. How's that for civility? She wrote I said, Michelle, it's one of the top 5 nice things anybody's ever done in my life. She literally sat down, printed out, and signed it. Right then, on the spot. So there is something to the civility thing. So even though we were opposition, we were opposed in counsel, we just had this wonderful relationship. So civil behavior is a core element of attorney professionalism. As the guardians of the rule of law that defines the American social and political fabric, lawyers should embody civility in all they do. Not only do lawyers serve as representatives of their clients, they serve as officers of the legal system and public citizens, having special responsibility for the quality of justice. To fulfill these overarching and overlapping roles, lawyers must make civility their professional standard and ideal. Thank you very much. Any questions for me? Any questions? Thank you very much. Any questions? Sometimes people have questions like, how do you say, what happens at this? You know, yes?
So those hypotheticals, those were all in-court statements?
Yes, except the ones in briefs.
Yeah. I mean, they were in the context of the court.
Yes.
If we have a case where things are leaning that direction, but a lot of the statements are being made in the press, which also implicates the rule about civility and kind of press statements. Being that they're out-of-court statements, that kind of adds a level of difficulty to getting contempt, but is there...
What I would do is I would bring it to the court's attention, because then the court can bring it to counsel's attention, which then sets them up for a potential state bar complaint, right? So you bring it to the court's attention, Your Honor, these things are being said, and I think this violates, the rules of civility. And give that particular quote, give the citation, have it on the record. Now it's on the record. The person to be hard pressed, they keep doing it. And it comes out that they violated the rule. They were told that was wrong, and they kept doing it. It's going to look really bad. Yeah, that's what I would do with that. Good question. Any other questions for me? Thank you guys so much. Great to be here.